Dear friends, before addressing Bill C-7, it is important to get our facts straight. I have fought against medical aid in dying for many years, before the courts and before our legislators. And I've done so from a legal point of view as a lawyer. Tonight, I would like to address the issue as a Christian. Medical aid in dying began to be permitted in Quebec on December 10, 2015, and in the rest of Canada as a whole on June 17, 2016. It should be remembered that prior to these laws, it was, and it still is permitted to refuse, to interrupt, or to stop a treatment, even if it could accelerate death. The same was and is true for sedation, the relief of pain, even to the point of unconsciousness, as long as the sedation is done without intent to cause death, even if it could accelerate death. It is then a question of letting die rather than causing death. This is permitted not only by virtue of our laws, but also by virtue of the position taken by the Catholic Church throughout the years, starting with Pope Pius XII in 1951, and followed by John the 23rd, Paul VI, John Paul II, Benedict XVI, and the more recent declarations of Pope Francis, all of whom recognized the ethical character of these decisions, but all condemned euthanasia and assisted suicide in all their forms. This position is summed up in the Catechism of the Catholic Church at numbers 2276 to 2279. With the coming into force in Quebec of Bill 52 on December 10, 2015, it became permissible for a physician to practice euthanasia, called medical aid in dying, to a person of full age, capable of giving consent, suffering from a serious and incurable illness, being in an advanced and irreversible decline in capability, and experiencing constant and unbearable physical or psychological suffering that cannot be relieved in a manner the patient deems tolerable. However, the person had to be considered to be at the end of life. In fact, the entire scope of this Quebec law was precisely about end-of-life care, hence its title, An Act Respecting End-of-Life Care. When it was adopted, both Mrs. Yvon and Dr. Barrett reiterated that only persons at the end of life would be eligible for medical aid in dying. As for people suffering from degenerative illnesses, they too were eligible, but only when they reached this final stage of life. On February 6, 2015, the Supreme Court of Canada, in a decision known as Carter, struck down the provisions of the Criminal Code that prohibited euthanasia and assisted suicide, even at the request of a suffering person, on the grounds that these provisions violated the right to life, liberty, and security of the person guaranteed by Section 7 of the Canadian Charter of Rights and Freedom. Following this decision, the Federal Parliament amended the Criminal Code by Bill C-14, which came into force on June 17, 2016, to allow not only euthanasia as in Quebec, but also assisted suicide, as long as these acts were performed by a physician or nurse practitioner to any adult who has a serious and irremediable medical condition. The Criminal Code uses the phrase medical assistance in dying to describe both euthanasia and assisted suicide, whilst the Quebec law uses medical aid in dying to describe only euthanasia. Contrary to the Quebec law, the Criminal Code, as amended by C-14, allows medical assistance in dying, not only in the event of an illness, but also for persons suffering from a serious and incurable disease or disability. Unlike Quebec, which specifies in its law that medical aid in dying is only permitted for people at the end of life, the amendments to the Criminal Code allow medical assistance in dying in the form of euthanasia or assisted suicide to persons whose natural death is reasonably foreseeable. A very vague criterion indeed, which was interpreted rather strictly at the beginning of the coming into force of these provisions in 2016, but which has been interpreted more and more broadly over time, particularly at the instigation of physicians who practice medical aid in dying. And then in the decision rendered on September 11, 2019, known as Truchon, a very publicized decision, the Superior Court of Quebec invalidated the end-of-life eligibility criterion in the Quebec law and the reasonably foreseeable natural death criterion in the Criminal Code as being discriminatory against persons who are equally suffering, but not at the end of their lives. The Quebec and federal governments chose not to defend their laws and not to appeal the decision. The fact that the decision was rendered in the middle of a federal election campaign did not help. Quebec decided not to amend Bill 52 and simply to no longer take into account the end-of-life criterion to be eligible for euthanasia. By contrast, the federal government decided to amend the Criminal Code to address the invalidation of the reasonably foreseeable natural death criterion, and this is what we want to discuss tonight. Here we are with Bill C-7, a federal bill to amend the Criminal Code, which is currently being debated in the federal parliament. C-7 allows for euthanasia and assisted suicide for people who are not at the end of their life, as the court requested in Truchon, but it goes much further. C-7 proposes to eliminate several safeguards adopted in the current version of the Criminal Code or to water them down. C-7 proposes different safeguards depending on whether one is at the end of life or not. Let's begin by examining the safeguards for those who are at the end of their life, or, as the Criminal Code says, those whose natural death is reasonably foreseeable. I must stress that the modification or deletion of these safeguard measures for persons who are at the end of life is an initiative of the federal government that was not necessary to comply with Truchon. And this is done for people who are at the end of life without any public debate, notwithstanding the fact that the current law is due to be re-examined by the federal parliament as early as the beginning of 2021. Currently, the written request for medical assistance in dying must be signed by the person requesting it before two independent witnesses. This was deemed necessary to prevent undue pressure on the person. Now, C-7 proposes that only one witness would be necessary, which leaves room for all sorts of more or less subtle pressures from the medical personnel, or even the patient's family. In the current federal law, a 10-day delay is required between the request for medical assistance in dying and the performance of this act. A very short delay indeed, but deemed necessary to allow the patient a period of reflection before this irreversible act. However, under current law, even this short period of time may be shortened if the physician or nurse deems that the person's death or loss of capacity to consent is imminent. C-7 proposes to eliminate the 10-day cooling-off period so that it would be possible to seek and obtain medical assistance in dying on the same day. This would introduce death on demand. And what a death. You're guaranteed to die at the time and on the day of your choice, with or without your family, by a rather quick death. And you're sure of the result because the act is performed by a professional. That's where we are now. But there is more. Currently, the criminal code requires that immediately before receiving medical assistance in dying, the patient must be given the opportunity to withdraw his or her request and must expressly consent to receive medical assistance in dying. This requires, of course, that the person be of full capacity and conscious. Well, on the basis that some people are currently unable to receive medical assistance in dying because they have lost the capacity to consent at the time the physician is about to do so, C-7 now proposes to allow this requirement to be waived and medical assistance in dying be nevertheless provided if before the person loses the capacity to consent, that person has entered into a written agreement to do so. However, if at the time of the injection the person expresses his or her refusal or resistance by words, gestures, or sounds, it cannot be administered. But C-7 goes even further. It even states that involuntary words, sounds, or gestures in response to contact do not constitute a manifestation of refusal or resistance. In practice, as the two doctors who performed the most euthanasia in Quebec, one in Quebec City and the other one in the Montreal area, admitted at a public meeting that I attended on January 27, 2020, this poses no problem in practice, since if the patient is agitated, he or she is given a sedative. And once the agitation ceases, euthanasia is carried out. Furthermore, C-7 even provides that if a person, whether at the end of life or not, loses capacity to consent after self-administering a substance provided by a physician or nurse to cause death, but death has not occurred, then the physician or nurse may still administer medical assistance in dying if the person had already entered into a written arrangement to do so. In other words, the doctor or nurse is allowed to, what I would say, finish the job in the case of a failed suicide attempt. What a society we are preparing for, a society that advocates a culture of death rather than a culture of life. Let's now come to what has become necessary to comply with the Truchon decision: the introduction by C-7 of medical assistance in dying for those who are not at the end of life. These may be people who are ill, those with one or more disabilities, or those with a medical condition, for example, as a result of a car or work accident. Of course, their medical situation must be serious, incurable, and characterized by an advanced an irreversible decline in capability and must cause them enduring, intolerable physical or psychological suffering which cannot be alleviated under conditions that they consider acceptable. But these people are not at the end of their lives. Of course, we will be told that C-7 has safeguards in place to prevent abuse. The person must meet all criteria. His or her request must have been made after being advised that he or she has a grievous and irremediable medical condition. But then the person is in a state of shock caused by the announcement. How can that person make a free, reasoned, and enlightened decision to end his or her life at that moment? Of course, they must have been informed that they can withdraw their request at any time. Compliance with the criteria must have been confirmed by 2 independent doctors or a doctor and a nurse, one of whom is an expert in the condition causing the person's suffering. Before performing the act, the physician or nurse must ensure that the person has been informed of the means available to relieve their suffering, and must also ensure that the professional who will perform the act and the other physician or nurse have discussed with that patient the reasonable and available means to relieve the person's suffering, and that both the person who will provide medical assistance in dying and the other doctor or nurse agree with the person that the person has given serious consideration to those means, but not that these means are available or that the person has at least tried them. And finally, there must be a period of 90 days between the first assessment and the day the medical assistance in dying is given. But, as in the case of a person at the end of life, this period may be shortened if the loss of capacity to provide consent is imminent. Think, of course, of people with Alzheimer's disease who generally survive for about 10 years. Think of those with Parkinson's. Think of people newly disabled following an accident who do not have enough of 90 days to adapt to their new condition. These are all people that C-7 puts at risk. Even the United Nations Special Rapporteur on the Rights of Persons with Disabilities, in her preliminary observations of April 12, 2019, noted that our federal government, and I'm quoting, still lags behind in the implementation of its obligations under the Convention on the Rights of Persons with Disabilities. And in her final report issued after the Truchon decision, she raised the fact that the ruling, and I quote again, might put additional pressure on persons with disabilities who are in a vulnerable situation due to insufficient community support. She even added, as many persons with disabilities said during the visit, they are being offered the choice between a nursing home and medical assistance in dying. This has led a group of religious leaders of all faiths, a group of lawyers, another group of health professionals, and finally, several disability advocacy groups to call on the federal government to back down. Are we as Christians going to remain indifferent? Are we going to remain silent in the face of the advances of this culture of death? Or are we going to defend life, as we have all done in this time of pandemic and as we continue to do? Are we going to commit ourselves to denouncing this situation by contacting our MPs to express our concern? Because we must be the defenders of life up to its natural end. And in closing, I would be remiss if I did not repeat the words of Pope Francis. On September 28, 2013, during an audience with Italian gynecologists, Pope Francis said, "Things have a price and are saleable, but persons have a dignity. They are worth much more than things, and they have no price. Because of this, attention to human life in its totality has become in recent times a real and proper priority of the magisterium of the Church, particularly for life which is largely defenseless, namely that of the disabled, the sick, the unborn, the children, the elderly. And he added, every elderly person, even if she is sick, or at the end of his or her days, bears in him or herself the face of Christ. We cannot reject them. As the culture of waste proposes to us, they cannot be discarded, said the Pope. And the Pope added a call to action that is also addressed to each of us. And I quote, "Your being Catholics entails a greater responsibility. First of all, towards yourselves, for the commitment of coherence with your Christian vocation, and then towards contemporary culture, to contribute to recognize in human life the transcendent dimension, the imprint of the creative work of God. This is a commitment to the new evangelization, which requires often going against the current, paying with your person. The Lord also counts on you to spread the gospel of life," ended the Pope. And the Lord also counts on each of us.